Thank you, Madam Speaker. Madam Speaker, I rise to give a brief statement on the half-year results and cruise tourism strategy in respect to tourism and ports. Madam Speaker, with tourism being the second pillar of our economy, I thank you for allowing me this opportunity to provide a brief overview of our tourism industry's half-year performance results. In so doing, I will compare where we are now to where we were pre-pandemic in 2019 to illustrate how the industry is recovering. For the first 6 months of the year, Madam Speaker, between January to June of 2023, the Cayman Islands welcomed 235,370 stayover visitors, which represents close to 84% of our visitor arrivals registered in the corresponding period of January to June of 2019. Canada was the second largest source of visitors with 7.5%, equating to an increase of 0.9% points from the 2019 year. And Europe followed in third place with a 4.4% of visitors, which was similar to the corresponding period in 2019. From a revenue perspective, Madam Speaker, results are equally as good, if not better. Between January and June 2023, revenues collected by the Department of Tourism for tourism accommodation tax amounted to 28.8 million, as you heard the Honorable Premier say earlier in his previous statement. This is 12.4 million ahead of the mid-year projections and 3 million over the target anticipated for the full year, Madam Speaker. In other words, Madam Speaker, the level of revenues anticipated for the full year was collected in the first 6 months of the year by June of 2023. Madam Speaker, I think that is worthy to be noted. What this essentially means, Madam Speaker, is the country is earning more per visitor. So while visitation is still slightly below the 2019 levels, we are making more money per capita. This increase is due to a significant rise in the average daily rate of the hotel accommodations over the past year and is an indication of a strong and sustained interest in the Cayman Islands as a premier travel destination. Data is still coming in, but what we are being told anecdotally by the industry is that occupancy levels during the summer is holding steady and in many instances are better than what it used to be in the norm pre-pandemic. And Madam Speaker, I would say those comments are specific to the month of July, as we're still awaiting the final numbers for August. And obviously, Madam Speaker, we're still in the month of September, so we won't know the numbers for those. Prior to 2020, it would not be unusual for occupancy to dip to approximately 50%. This year, occupancy levels for the month of June have been averaging as high as 70% of the 2019 occupancy numbers. If you compare the 2 to 3 slow months of the year, you'll see that we have been doing better in 2023 than in 2019 as per the slow months. This shows that the industry is bouncing back to where we were, not just prior to the pandemic, but where we were in our highest record-breaking year of 2019 under the leadership of the former Minister, the Honorable Moses Kokorno. Madam Speaker, if we were to extrapolate these half-year results across the full year, we can say with some degree of comfort that based on the current trajectory, we are optimistic of meeting or exceeding our stayover visitation targets of 70% or more. Looking at quarter three, the months of July and August have also outperformed projections. September numbers are not in yet to be able to do a like-for-like comparison of the entire quarter, which encompasses July, August, and September. But the indications are that both visitation and revenue figures are on target without any cause for concern. Madam Speaker, even in the cruise sector, which was projected to take a full year to reach the 70% of the 2019 passenger arrivals, trends are indicating that we are on track to surpass our target. Cruise passenger arrivals for the first half of the year amounted to 738,462 passengers, or 73% of the 2019 pre-pandemic visitation numbers. Revenue collected for cruise passenger departure tax amounted to CI 4.4 million, which is approximately 6% ahead of the mid-year forecast. When I delivered my budget address when Parliament meets next month, I will go into more depth with these statistics. But I feel it is important that we take this opportunity to share this information with members and update the public on the true position regarding our tourism industry performance. To put these results in context, Madam Speaker, it is important to remember that our borders only fully opened a year ago, and straight out of the gate, my ministry set a goal to obtain 40% of the 2019 arrival numbers for the year 2022. And for yet more context, Madam Speaker, let me state that the 2019 arrivals for the full year were the highest in the country's history. So our benchmark was quite high. Notwithstanding, I challenged my ministry and the Department of Tourism to achieve almost half of that historic record-breaking number, with our borders only fully being reopened for 4 months. How anyone can think that we have lowballed the target against that stark reality is beyond me, Madam Speaker. Having achieved the goal for 2022, the arrivals target for 2023 was increased to 70%. Perhaps it can be argued that for 2023, borders would have been open for a full year, so we're only aiming for 70% of the 2019 numbers, one would ask. The answer is, Madam Speaker, on a global scale, a number of factors are impeding people's ability and willingness to travel. This includes the residual effects of the pandemic, where airlines are still having to cancel flights due to staff shortages, coupled with rising cost of living, higher mortgage interest rates, just to name a few. When economic factors start to impact daily life, people tend to differentiate between needs and wants, Madam Speaker, which includes rethinking travel decisions, often putting them off till the economic environment is more stable and favorable. The saving grace for the Cayman Islands, Madam Speaker, against this reality is the fact that we target a higher net worth individuals who are more insulated against sudden economic shocks. But what we cannot mitigate against, Madam Speaker, are the global realities which exist beyond our shores, which we have no control over. And so, with all of those realities in mind, we set a realistic target of 70%, or approximately 300,000 passengers. And Madam Speaker, I would say that that target was appropriate, as we are maintaining just 4% above it at the halfway mark. Madam Speaker, while I welcome this opportunity to update members on our tourism performance, I am particularly keen to explain to the members of this House and the public what my ministry is doing to grow a resilient and sustainable cruise tourism sector. I am aware that members of the opposition have expressed concerns about the decline in cruise calls compared to the pre-pandemic cruise ship arrivals, and I have to say, Madam Speaker, I'm a little bit surprised by their actions. It should not come as a surprise to anybody, Madam Speaker, least of all the opposition, that for logistical reasons, cruise lines are unwilling to disembark passengers on the mega-class ships by tender. The public was made aware that without piers, cruise calls would gradually reduce over time as the cruise lines transitioned to larger vessels. We cannot do anything about what the people wanted in respect to their decision about having a berthing facility. But what we can do, Madam Speaker, and we are doing, is focusing on increasing stayover visitation to bring more revenue into our country. At the same time, Madam Speaker, we're also working hard to increase the value proposition from each cruise passenger so that operators in this space can still make a good living and earning just as much or almost as much money from the reduced cruise passenger headcount. This is why my ministry is taking a fresh look at the business model and concentrating on quality over quantity aspects of the industry to compensate for the drop in passenger numbers due to the country not having piers. If that stance is not in line with the opposition's position, I'll accept that for what it is, Madam Speaker. But this is what I do believe the people want and have expressed when they made their decision, when they made their position on the piers clear. Does it come with some disadvantages? Yes, Madam Speaker, it does. But the people spoke loudly and clearly on what they wanted and what they didn't want. Madam Speaker, we are representatives of the people, and if the people's opinion has changed in that respect, then our job is to represent the people's viewpoint. Now, Madam Speaker, I can confidently say that I have received no indication from the public in this regard, not as a representative or as the minister responsible for tourism. I have not heard the kind of pushback that the Deputy Leader of Opposition have expressed in a video released by the Progressives a short while ago. You may recall, Madam Speaker, that in a previous sitting of this Honourable House, I stated that I would be spearheading the creation of a comprehensive cruise tourism strategy that will guide our path forward in this sector. My team and I have been diligently working on the development of that document, which will take into account environmental impacts, carrying capacity, social responsibility, and the integration of cruise tourism within the local community. We recognize that there is a need for a well-thought-out plan that not only addresses the current challenges, but also capitalizes on the opportunities that lie ahead. The strategy is not only about economic prosperity, it is about preserving our natural beauty, Madam Speaker, protecting our culture and ensuring a high-quality experience for both tourists and residents alike. In the next sitting of Parliament, when we present the budget, I will speak more on the finer details of the cruise tourism strategy and what each section looks at, and what the next steps in the process will be. But one thing I would like to state now regarding the development process is that I've chosen to develop the strategy in-house within my ministry and within the Department of Tourism. By utilizing the expertise within our government agencies, consulting with local and international experts, where needed, and harnessing the knowledge of our dedicated civil servants, I believe we can create a strategy that is uniquely tailored to our island's needs while saving hundreds of thousands of dollars that would otherwise have been spent on consultancy fees, Madam Speaker. Instead, we are drawing on the talents and the capabilities of our own people locally, which not only makes fiscal sense, but also instills a sense of ownership and pride in the outcome. This in-house approach does not preclude collaboration with external partners, Madam Speaker, but as the strategy develops, if the need arises, we will engage with experts, academics, and even look towards other countries that have successfully navigated similar challenges to gather insights and best practices. We are committed to a transparent and consultative process, ensuring that our strategy reflects the collective wisdom of our global and local communities. I look forward to elaborating more in the next sitting of Parliament when we present the budget, Madam Speaker. But rest assured that I remain committed to transparency, accountability, and inclusivity every step of the way. As we move forward, it goes without saying that my ministry staff and I are keenly aware of the significance of the cruise tourism industry to this country and to our people. And we recognize the importance of striking a balance. And Madam Speaker, you would have heard the Honourable Premier hone in on the word balance, and that's what this government is trying to juggle between the economic growth and environmental stewardship. This strategy will be a dynamic document, adaptable to changing circumstances and responsive to the evolving needs of our community and our tourism industry, particularly that of the cruise industry. Madam Speaker, I look forward to presenting it to the public earlier in the new year. Thank you, Madam Speaker. Madam Speaker, I, by your grace, was offered the opportunity to give two statements. This new statement is on behalf of the Cayman Islands Craft Market. Madam Speaker, I stand before you today to provide the members of this Honourable House with an update on the Cayman Islands Craft Market and its move to a new temporary location. Madam Speaker, in August 2021, while the borders were still closed, TAB, now known as the Cayman Islands National Attractions Authority, received formal notice from the landlord signaling the end of the craft market's tenancy at the intersection of Boilers Road and South Church Street, effective January 2022. Consequently, the site that the craft market had occupied for many years was vacated as requested by the owners. The relocation of the craft market was a strategic response to evolving circumstances. In March 2022, in anticipation of the return of cruise ships, the site of the old tower building was chosen to become the temporary new location due to its convenient proximity to the port. The space was cleaned and resurfaced, and small tents were purchased to accommodate approximately 8 vendors. 5 months later, in August 2022, after consultation with the Port Authority, enhancements were undertaken to improve the site for vendors and elevate the overall visitor experience. These upgrades include, but not limited to, a reconfigured layout which provides more space for commercial activity, the installation of a spacious 60 by 40 tent, upgraded parking facilities which can accommodate approximately 25 vendors, all within a visually pleasing environment. The entrance was redesigned so to separate pedestrian and car access. ensuring a seamless flow of foot traffic while enhancing safety and accessibility. Feather flags and signage were installed to attract attention and heighten visibility of the craft market's presence in that new location. Madam Speaker, it is acknowledged that the setup at the Old Tower Building location is a temporary solution, and I emphasize, Madam Speaker, a temporary solution until the craft market is able to move to its more permanent location at the Tourism Waterfront Experience Project, which is just north of the Lobster Pot restaurant. The anticipated timeline for completion of that project is the year 2025. Consequently, all of the enhancements that have been put in place are temporary in nature and can easily be dismantled so not to hinder any future plans at the Tower Building site. From an end user perspective, a meeting was held with the craft market vendors on August the 26th of this year, and their feedback was positive, expressing contentment with the space that they have been provided. Given the additional time that the craft market would have to remain at the Tower Building site, and in an effort to keep our tourism product at acceptable levels, certain works will be carried out in the immediate future. And Madam Speaker, I recall a member requesting knowledge of any updates to the location. These include some landscaping of the space, a shift to the center of the property, and an expansion of the area of pavers to accommodate the tent-covered vending space, a refreshing of the signage, and fencing repairs. And Madam Speaker, those are the substantial major changes, but we will be beautifying the area as well with more vegetation. Madam Speaker, in providing this update, I would like to place on the record my thanks to the Honorable Premier for his support and agreement that the Cayman Islands Craft Market continue to operate at the site of the former Tower Building under the management of the Cayman Islands National Attractions Authority. As you know, Madam Speaker, the location is allocated for another project. While the aesthetics and the physical comfort at the site are essential, my ministry remains committed to addressing all aspects of the craft market's transition. In December 2022, our attention was drawn to concerns regarding items being sold at the craft market that were acquired from wholesale souvenir suppliers. This goes against the Craft Market Code of Conduct, which states that products sold at the craft market have to be either made locally or finished locally. In January 2023, the Director of the Cayman Islands National Attractions Authority and the Administrative Officer with responsibility for the site met with vendors' representatives before proceeding to inspect their products being sold. Following the inspection, several vendors were issued warning letters for breaching the Code of Conduct. Unfortunately, this did not resolve the issue, as just a few months later, in May of this year, reports were again received by the ministry that some vendors were still selling products that were purchased from wholesale souvenir shops. The Director of the Cayman Islands National Attractions Authority emphasized the need for compliance, reiterating that only authentic Caymanian-made products that were either made or finished in the Cayman Islands should and can be sold at the market. And considerations was given to suspending recurring offenders. Aside from the issue of non-compliance, which now seems to be resolved, Madam Speaker, during a routine site inspection in February of this year, maintenance staff discovered that a section of the canvas of the tent was damaged. A replacement tent was purchased on the advice of the maintenance team, and sidings were also installed to provide more protection during the rainy season. Looking to the future now, Madam Speaker, in keeping with the government's commitment to to skills development and training. Plans are in place for the craft market vendors and their representatives to undergo Pride recertification training. The first session will occur later this month, and other sessions will follow in due course. The Cayman Islands National Attractions Authority also intends to develop partnerships with shop owners at the port to provide direct promotions of the market to disembarking passengers. A new survey tool will be launched to track the number of visitors to the site and to ascertain their satisfaction with the market and their interactions with vendors. I'm happy to note, Madam Speaker, that earlier this year, 4 new applicants were interviewed and all have been recommended to license them as new vendors, subsequent to receiving their Pride training and certification from the Department of Tourism. In conclusion, Madam Speaker, I would like to express my gratitude to all of those involved in the relocating and enhancing the Cayman Islands craft market at its new temporary location. The collaborative efforts of our government teams, the Cayman Islands National Attractions Authority, and our valued stakeholders have been instrumental in creating an attractive and visitor-friendly atmosphere that functions well and is pleasing to vendors. With that said, Madam Speaker, I take this opportunity to affirm that I will continue to work tirelessly to ensure that the Cayman Islands remain as a destination of choice, offering enriching and memorable experiences for all, even from a temporary location and structure if needs be. Thank you, Madam Speaker.
I've also given leave to the Minister for Planning, Agriculture, Housing and Infrastructure to make a few statements.
Madam Speaker, thank you so much. Madam Speaker, I wish to make a short statement as to the circumstances surrounding to the Ministry of Planning, Agriculture, Housing and Infrastructure, requesting for the increase in allocation of funds according to Section 11.5 of Public Management Finance Act 2020 revision. In 2022, several ministry entities realized a shortfall in funding due to the increased cost of services. To alleviate the shortfall and accommodate the 22 budget, Cabinet approved a number of reallocations at the end of the year, last year. In such inaction, the Ministry primarily utilized internal savings in 2022 to facilitate the reallocation. However, by doing this, the following appropriations from which funds were transferred and have since required additional funding. PH 10, Management of Government Properties, receiving additional funding in the amount of $393.077. The Facility Management Department anticipated that operation costs such as the utilities and security services will continue to increase based on the trend of the current expenditures. Funding utilized ensure the smooth functioning and necessary services, allowing the government officials and staff to carry out their duties effectively. Without proper utilities like electricity and cooling, operation could be severely disrupted, leading to the delays in decision-making and service delivery. The Facility Management Department supplies and consumable revised 2023 budget is $3,801,234, a reduction of almost $300,000 or just under 8% of the 2022 budget year. Forecasts indicated costs of overruns by the end of the year are approximately of $285,897 or 7.5% of the 2023 budget. To PH 14, Management of Planning applications, receiving an additional of $300,000, the Planning Department had some unexpected expenses that were realized during the 2023 preliminary as a result of the appeal of the court cases between NCC and the DOP. The Cayman investment property, while funds have been originally budgeted for the appeal costs, were somewhat higher than expected. The cover and expenses the ministry transferred funds from the planning personal appropriation to the department supplies and consumables in the amount of $300,000. Consequently, additional funds were required to cover the personal costs that was transferred to the supplies and consumables. Without these funds being replaced, the DOP could not complete its recruitment exercise, such as recruiting its necessaries to respond to the demand and the growth of the industry. There are a number of projects that are in the development pipeline, including the redevelopment of the Westin Hotel, the Prisma, the 1GT, the Locovia. These projects totaling of over $500 million in the development and require multiple reviews and inspectors overall. And the department was recorded and proceeds are over of $3 billion in the development, therefore gathering a significant planning and building fees in the government. PH 16, license for drivers of vehicle received $400,000 in supplementary expenditures and was requested for expenditures related to the DVDL due to a significant increase in the number of vehicles during the registered license. For example, Madam Speaker, the number of vehicles added to the registered had increased from just over 50,000 at the end of 2021 now to around 60,000. This has required additional resources and staffing. Having said that, the DVDL has also performed well financial collecting of some $7,390,012 for the year thus far. Having said that, 3 entities received a total of $1,093.77 of newly appropriated funds, which led to an overall increase in the budget. Madam Speaker, the funding appropriated are all important to the government's broad outcome 3, that is to provide a solution to the improvement of the well-being of our people so they can achieve their full potential. I would like to take this opportunity to just thank the Honorable House for their continued support. Madam Speaker, I just want to move on to funding for the National Housing Development Trust in Housing Repairs Program. Madam Speaker, I wish to make a short statement as to the circumstances surrounding that the Ministry of Planning, Agriculture and Funds pursuant to Section 11.5. Madam Speaker, the Ministry requested an appropriation of funds from the existing EI 161 submarine cable allocation to increase EI 57 National Housing Development Trust allocation by $500,000 to carry out the housing repairs. The National Housing Development Trust currently facilitated the management of the Government Affordable Housing Program. Madam Speaker, the trust is typically funded through an EI, which is used to repay its expenses such as overheads and loans. The loans are in turn utilized to subsidize the construction of affordable housing for Caymanians. Madam Speaker, the additional funding will continue to assist the Caymanians, including the elderly, single parents, households, and low-income households, who are unable to complete essential home repairs, whether the damages as a result of storms or otherwise, due to the financial position and some insurance situations. Madam Speaker, the government is actually aware that have Caymanians who are struggling financially due to various factors, such as high cost of living and high construction costs. While we are working on a solution of this, other fronts we cannot ignore our people that would not be able to undertake the required home repairs without assistance, putting their health and safety and others as at risk. The trust will manage and disperse payments when the work is undertaken, is certified, and is as completed according to its established National Housing Repairs Program. Madam Speaker, the funding appropriated are all imported to the government's broad outcome 3, that is to provide a solution to improve the well-being of our people so they can achieve their full potential. Madam Speaker, with your allowance, I will speak to the reallocation of funding for projects needing an additional budget for 2023. Madam Speaker, I wish to make a short statement as to the circumstances surrounding the Ministry of Planning, Agriculture, Housing, Infrastructure requests for reallocation of funds during the third quarter 2023 pursuant to Section 11.5. Madam Speaker, these funds relate to entities within the internal service special projects sections of the ministry that realizes a shortfall of funding due to the increase of costs of services. To assist with the shortfalls, 1.325 million were reallocated from Executive Capital EA 160, design and construction of a new civic center, and awarded as follows: to EA 78, Government Administration Building, in the amount of 400,000. The administration building serves as the hub for various essentials and functions relating to the public service and the government's policy making, and the government's core data center. This funding will also assist in the necessary maintenance and improvements to the building and allow for the replenishment of necessary furnishing. Now to EA 151, ramps and jetties, in the amount of 425. Our ramps and jetties are heavily utilized by cross-section of our community, and many across the island are in dire needs of repairs. These funds will facilitate the upgrades and refurbishment of the ramps, jetties throughout the country. Madam Speaker, I should note that the ministry will continue to work through these repairs over the coming months. Now to EA 153, park upgrades, in the amount of 500,000. To assist the funding to creating and improving the district parks and serve as a gathering place for the community. Parks are proven and highly desired natural community enhancements. As such, the need for parks have grown. Again, Madam Speaker, and I have note that the development and improvement of our parks are a priority of the government. Madam Speaker, I mentioned earlier that the funds were reallocated from within PIE's existing appropriation, specifically the EA 160, the design of the construction of the new civic center. While the design of the new civic centers for the Northward is currently underway, the entire appropriation will not be fully utilized this year. Therefore, as you can appreciate, Madam Speaker, it was more physically prudent to reallocate these funds in order to minimize the increase of overall budget. Madam Speaker, the funding reallocation here are all important to the government's broad outcome 3, and it's now in to provide a solution to improve the well-being of our people so they can achieve their full potential. I would like to take the opportunity to thank the honorable members of the House for their continued support, and thank you, Madam Speaker. May God bless these Cayman Islands.
Last statement. Before we move on to the next statement, I call on the Honourable Leader of the Opposition.
Madam Speaker, I just crave your indulgence to ask the Minister a couple of questions on his statement, if I might.
You may proceed.
Thank you, Madam Speaker. Through you to the Minister, trying to understand clearly what is the net increase in additional spending, if any, in these. If I could just walk you through the one you just read with regard to the EA 160 to fund EA 78, 151. That's a straight reallocation. Net effect is zero. No net additional spending. And then the second one you read with regard to the allocation from the subsea cable, net effect is zero. no net additional spending there, am I correct? So it was the third one, which I think is the first statement that was made. It was not specifically clear to me if this results in additional spending or whether there was a reallocation and where it came from. You talked about there was a discussion about, mentioned that the shortfall in the 2022 budget, and the cabinet approved a number of reallocations to the end of last year. If I might continue to read, as a result of that, the following appropriations from which funds were transferred have required additional funding, and it wasn't clear to me whether that was increase in additional spending or a reallocation from other budget. I'm speaking of the additional spending for PAH 10, Management of Government Properties, PAH 14, Management of Planning Applications for $300,000, and PAH 16, Licensings of Drivers and Vehicles of $400,000. So all in this, your first statement, sir, there was approvals granted for about looks to me like just over $1 million. So I'm just seeking clarity as to whether it was accomplished by reallocating or transferring via 11.5, or whether it was an appropriation via Section 11.5.
Madam Speaker, if the member would allow us to do, we would undertake and maybe speak with him and just so we can just correspond with him and just make sure he understands the switching that he was asking about, because I think I'm a little bit off with which number he was talking about.
Honourable Minister, can I just make a suggestion that perhaps this question could be asked at Finance Committee and answered at that time? Honourable Leader of the Opposition.
Reluctantly, I would agree, Madam Speaker, simply because this is a statement on the floor of the House, what we will discuss in Finance Committee. Well, question is whether something like this would be coming in the Finance Committee document. And I don't know that. I have no idea what's coming on Friday in terms of Finance Committee. I just don't want to lose it. I wanted to understand whether, as a result of this statement, with these three amounts totaling about $1 million, whether that increases the government spending or whether it is a reallocation from other appropriations to cover the shortfall. That's what I'm just seeking clarity on. Madam Speaker, I My question has been answered, because what I didn't read carefully was the very last statement, that it results, the total of $1,093,000 of newly appropriated funds, which led to an overall increase in the budget. And that's what I was really seeking after. So my apologies.
Thank you, honourable members. Now that we have that sorted, I will give leave to the Honourable Attorney General to make a statement.
Thank you, Madam Speaker. Madam Speaker, I rise to make a statement in relation to exceptional circumstances, transactions incurred during the 2022 and 2023 financial years for the Office of the Director of Public Prosecutions. Madam Speaker, pursuant to Section 11(6) of the Public Management and Finance Act 2020 revision, this statement is in respect to exceptional circumstances which was approved by the Cabinet for the Office of the DPP, as I stated, during the 2022 and 2023 financial years. Madam Speaker, the exceptional circumstances required making changes to the 2022 and 2023 appropriations, which I will briefly explain. Funding totaling CI $1,065,374 was required in 2022 for the purpose of settling a cost order made following the discharge of an extradition order by the Grand Court. An additional $95,000 CI dollars was required in 2023 to cover the shortfall following a further court order in February of that year, Madam Speaker. This matter meets the definition of exceptional circumstance for the following reasons. A, once the extradition process commenced, the Office of the DPP was required to pursue the request on behalf of the U.S. government. B, the U.S. government had a good arguable case against Mr. McCullough, and the request for Mr. McCullough's extradition was properly made. The extradition order was discharged not due to a lack of merit as to the substance of the request. This, Madam Speaker, was acknowledged by the judge, Justice Linda Dobbs, in her judgments. The Grand Court initially ordered the sum of US $825,544.25 to be paid to the applicant in October of 2022. A further order followed in February of 2023 for US $559,368.50, as a result of which the total sum paid to the applicant was USD $1,384,912.75, or the CI equivalent of $1,159,864. Cabinet funding was sought and approved for an initial sum of CI $1,065,374 in October 2022 for the interim cost certificates handed down in court, along with an additional sum to satisfy the costs subject to taxation. However, Madam Speaker, once the judgment on the taxation of bills of costs was delivered, it was recognized that there was a shortfall of $95,000 CI. The funding in question was required for the purpose of giving effect to orders of the Grand Court in legal proceedings, the outcome of which could not have been predicted by the DPP. The orders gave rise to a significant legal liability for government, which required an immediate financial remedy. And relevant information relating to the case and potential outcome, inclusive of the associated financial implications in the event of an unsuccessful judgment, had not been established at the time of the enactment of the Appropriation Act for the financial years 2022 and 2023. As such, Madam Speaker, the Office of the DPP did not include amounts for such settlement of claims within its budget. Total funding of CI $1,065,374 for 2022 and CI $95,000 for 2023 was therefore sought to cover this exceptional expenditure. Madam Speaker, the following change was approved by Cabinet via Section 11.5. A. Increase 2022 appropriation. The total appropriation increase OE 105, settlement of claim CI $1,065,374. B. Increased 2023 appropriation. Total appropriation increase OE 105, settlement of claim CI $95,000. In conclusion, Madam Speaker, the above exceptional circumstances which were approved by the Cabinet for the Office of the DPP during the 2022 and 2023 financial year, along with the overall effect on the government compliance with the principles of responsible financial management, can be found in the 2022 and 2023 supplementary bills. I thank you, Madam Speaker.
Personal explanations?
None.
Obituary and other ceremonial speeches?
None.
Raising of matters of privileges?
None.
Government business bills, second reading. Proceeds of Crime Amendment Bill 2023.
The Honourable Attorney General.
Thank you, Madam Speaker. Madam Speaker, I rise to move the second reading of a bill, the long title of which is Proceeds, Thank you, Madam Speaker. Thank you. Madam Speaker, I beg to move the second reading of a bill, a long title of which is a bill for an act to amend the Proceeds of Crime Act 2023 revision in order to reform that act in the areas of intelligence gathering and investigations to ensure that the Act conforms to international best practices, to clarify the evidential basis on which it may be shown that property is criminal property or is obtained through unlawful conduct, to amend the Act in order to protect self-regulatory bodies which are supervisory authorities from certain liability in the execution of their regulatory duties and for incidental and connected purposes.
The bill has been duly moved. Does the Honourable Attorney General wish to speak thereto?
Yes, Madam Speaker, thank you, with your leave. Madam Speaker, as you are no doubt aware, in recent years, the Cayman Islands has made significant improvements to its national anti-money laundering and counter-terrorism financing framework. These reforms, Madam Speaker, were as a result of deficiencies identified in part by the Caribbean Financial Action Task Force Neutral Evaluation Process, which we undergo in 2017. Some of the reforms, Madam Speaker, were also based on gaps identified from our own self-evaluation exercises, which were conducted by the island's authorities, either through national or sectoral risk assessments Despite the strides we have made in enhancing our AML safety regime, Madam Speaker, there is still some remnant work to be done. And so presenting this bill today is part of our continued sustained efforts, Madam Speaker, to fine-tune our AML safety framework and provide authorities that have critical AML safety mandates with the legal powers and protections to support that effort. The bill is therefore principally intended to do the following, Madam Speaker. One, strengthen the ability of the Office of the Director of Public Prosecution and investigative authorities to investigate and prosecute money laundering and terrorist financing offenses. Two, enable the sharing and exchange of information between relevant, competent, and supervisory authorities. And three, Madam Speaker, provide protection for DNF BPs, that is designated non-financial business and profession supervisors, against liability in the execution of their AML CFT functions. This last objective, Madam Speaker, is a particular critical imperative if these supervisors are to carry out their roles effectively. Madam Speaker, I will, with your leave, summarize the provisions of the Proceeds of Crime Amendment Bill 2023. Clause 1, as usual, contains a short title of the legislation. Clause 2, Madam Speaker, makes a miscellaneous amendment to drafting style of the legislation as it is done within the Cayman Islands. Clause 3, Madam Speaker, deals with definitions and interpretations. It provides for the definition of the terms appropriate officer, designated non-financial business and professions, as we call it, DNFBPs, self-regulatory bodies, SRBs, and also, Madam Speaker, definition of virtual assets. SRB, a self-regulatory body, is defined to support another proposed amendment that will be dealt with during the committee stage. The DNFBP, or designated non-financial business and profession, is defined in the bill, Madam Speaker, to be consistent with meaning specified in the anti-money laundering regulations, and to basically streamline the definition between those two pieces of legislation. The definition of appropriate officer, Madam Speaker, is inserted in the Act to specify precisely what that term means. Currently, Madam Speaker, there are some 27 references to the term in the Proceeds of Crime Act without any sort of clear definition of exactly what it means. Madam Speaker, Clause 3 also amends the definition of virtual asset to bring it in line with a definition that is found in the Virtual Asset Service Providers Act, VASPA, a piece of legislation that was piloted by the Ministry of Financial Services some time ago. Under that legislation, Madam Speaker, the definition of virtual asset aligns more closely with the FATF meaning of that term. And finally, Madam Speaker, Clause 3 repeals the definitions of property investment and a single-family office. The amendment to repeal property investment is associated, Madam Speaker, with another proposed amendment in this bill to remove property investment as a relevant financial business, and we'll speak to that later on as well. Similarly, Madam Speaker, the definition for single-family office is being repealed following a proposed amendment to remove from the Proceeds of Crime Act the operation of single-family office as a separately identified relevant financial business. Madam Speaker, operating a single-family office is deemed as a security investment business and therefore need not be identified separately from that categorization as a relevant financial business, nor is it need to be defined in the Proceeds of Crime Act. In other words, Madam Speaker, it will be dealt with under the Securities and Investment Business Act. Madam Speaker, Clause 4 repeals the meaning of single family, which is currently contained in Section 2A of the Proceeds of Crime Act. This amendment is related to, Madam Speaker, an associated amendment, as I said, to remove operating a single family office as a regulated business under Schedule 6 of the Act itself. With the removal, Madam Speaker, it is no longer necessary to have a definition of single family in the Act itself. Madam Speaker, Clause 5 of the amendment is an amendment in Section 4.2 CA, allowing the Financial Reporting Authority to exchange information. That is, Madam Speaker, information and results of any analysis with all relevant authorities or persons. Madam Speaker, we speak to that again also in committee stage. Madam Speaker, Clause 6 addresses two amendments. The first is to correct an error in Section 9.1 of the Proceeds of Crime Act by replacing the word of in the second line with the word or. The provision, Madam Speaker, Section 9.1 was meant to specify or to read that the disclosure should be made to the FRA or the nominated officer, not a nominated officer of the FRA. Indeed, there is no nominated officer in the FRA, Madam Speaker. The second amendment, Madam Speaker, regarding Section 9.1 is to make clear that the protection against disclosure to the FRA applies also when a person reports suspicion of terrorism or terrorist financing. This understanding, Madam Speaker, is not quite clear in the current language. In other words, Madam Speaker, if a person makes a report about an act of terrorism or an act of terrorist financing, actual offense, they're protected. However, if they make a report about a mere suspicion of those two offenses, it is not quite clear that their disclosure would be protected under the current framework, Madam Speaker. Madam Speaker, Clause 7, which inserts a new provision of protection for self-regulatory body, is a provision that we will speak to at committee stage as well. Clause 8 of the bill, Madam Speaker, amends Section 79.2 to make clear that with respect to civil recovery proceedings, property can be proven to be criminal property by circumstantial evidence. In other words, Madam Speaker, as we will see also in another clause, Clause 15, dealing with Section 144, I think, of the bill. Yeah. It is, the language there is, well, is unhappily worded, if I might put it that way. And it is not made quite clear that you can prove that property is criminal property, not simply by, or not just by actual evidence of criminality, but also by means of circumstantial evidence, Madam Speaker. So the language here is meant to make it clear that it can also be proven by circumstantial evidence. Madam Speaker, the amendment is intended to close the gap, as I say, in our legislative framework and align it more with international best practices relating to civil recovery, Madam Speaker, civil recovery matters. As currently worded, the civil recovery proceedings under the Proceeds of Crime Act requires criminal property to be proved by showing that the property arises from an identified specific unlawful activity. Madam Speaker, as I said, it ought to be able to do so as well by showing that by using circumstantial evidence to prove that. And I'd like to give an example of what we consider to be circumstantial evidence, Madam Speaker. I remember when we were prosecuting and you were addressing a jury in order to make it simple for them as to what we refer to as circumstantial evidence. We would give an example of if you have a cat and a piece of cheese in a barrel, and you put the piece of cheese and the cat in the barrel, cover the barrel for a while, and then later you went back, and the cheese is gone, the cat is there licking its lips. It could only be one inference, that is, that the cheese must have been devoured by, eaten by the cat. So that's a clear example of what we consider circumstantial evidence, Madam Speaker. The inference is inescapable. Madam Speaker, Clause 9 amends Section 82(4) to align it more closely with the UK Proceeds of Crime Act, clarify the requirements a court must satisfy to make a property freezing order upon application. The language in 824 tracks almost precisely the mirror provision in the UK's Proceeds of Crime Act, Section 245A, but is set out in such a way that a court must satisfy itself of at least 4 conditions noted in the section before it can grant a property freezing order. One, that the property which is the subject of the freezing order is recoverable property. I mean, it's property that is obtained by unlawful conduct, Madam Speaker. 2 is an associated property, and 3, for example, includes property which is alleged to be associated property. Under our framework, Madam Speaker, we have to prove all 4. The court has to be satisfied of all 4. Whereas under the UK legislation, which we try to mirror, Madam Speaker, and which our Proceeds of Crime Act is based, they are only required to be satisfied of 2 conditions. And of course, only if it is absolutely necessary would they be required to go on to consider additional 2 conditions. Madam Speaker, Clause 10 of the bill amends Section 110 of the Proceeds of Crime Act to define the term minimum amount, and that is in the context of recovery of cash seized during searches. The term minimum amount, Madam Speaker, is used a few times in Section 110 without any concrete understanding of what it means. And I will just see if I can find Section 110, Madam Speaker, to add some context to what I'm trying to say. So Section 110 of the Proceeds of Crime Act deals with recovery of cash in summary proceedings, and this speaks about searches. And it says, Madam Speaker, where a custom officer or a constable who is lawfully on any premises has reasonable grounds for suspecting that there is on the premises cash, which is recoverable property, which means, of course, Madam Speaker, that it is proceeds of crime, or is intended by any person for use in an unlawful conduct, the amount of which is not less than the minimum amount. However, Madam Speaker, there is no amount listed here. So what we're trying to do is put in a definition of what is the minimum amount. So it would read 10,000 Cayman Islands. Sorry, 1,000 Cayman Islands dollars, Madam Speaker. So it If the amount is less than 1,000 Cayman Islands dollars, then the search cannot take place because it falls below the threshold. It has to be 1,000 or more to trigger a search of premises, Madam Speaker, in addition to that. Madam Speaker, there are amendments to clauses 11, 12, and 13, which again we will refer to during the committee stage amendment. Clause 14, Madam Speaker, amends section 138(1)(b) of the Proceeds of Crime Act, and similar to an amendment in section 42(CA), which I spoke about, Madam Speaker, earlier under clause 5, and again to ensure that the FRA can share and exchange information relating to suspicions of criminal conduct with all competent and supervisory authorities in the jurisdiction with AML safety mandates, including, Madam Speaker, self-regulatory bodies such as the Cayman Islands Institute of Public Accountants, or CIPA, when they are dealing with money laundering supervision of their members, or to the regulatory body that supervises lawyers for regulatory body for money laundering, or to the NPO registrar, Madam Speaker. Currently under section 138(1)(b), the FRA can share and exchange information with the parties specified in the law. That is, Madam Speaker, with CIMA and the tax authority. But it is not legally authorized to share and exchange information on suspicion of criminal conduct with authorities such as the NPO registrar, with SILPA or CIPA. All, Madam Speaker, all of those agencies form part of the AML framework and are required to exchange information with the FRA. But there's no reciprocal sort of a framework at the moment for FRA to share and receive. So the amendment is intended to address that, Madam Speaker, because one of the critical things that we need to demonstrate under our AML framework is that there is the ability and capability to have what is called domestic cooperation and coordination among AML supervisors and competent authorities. So there's also now the emerging issue of sanctions, Russian sanctions. So if the FRA has information relating to some of these sanctions, they ought to be able to share that information with, for example, the Civil Aviation Authority or the Maritime Authority. So we provided all of these kinds of things. So what is being done, Madam Speaker, is instead of having all of these listings, we now revert into using the word competent authorities and supervisory authorities, and that is all more all-encompassing of all of these bodies. Madam Speaker, I spoke earlier about clause 15, which is section 144, to clarify the evidentiary requirements for proving that property is criminal property by aligning the provision more closely with the UK's case on which it is based. As currently written, Madam Speaker, and as I said, it is unhappily worded. Section 144 has been the subject of opposing interpretations, or different interpretations in our domestic courts, on the issue of whether the Crown must prove that an underlying specific crime, predicate offense, had occurred before it can prove money laundering in order to prove that the property is criminal property by the commission of this predicate offense. Madam Speaker, that has caused some uncertainty because of the different judges interpreting the section different ways. And that is quite understandable. But Section 144(5)(a), Madam Speaker, of our legislation is based in general terms on the common law principle in the decision of a UK Supreme Court case named the Queen against Anwar, which was decided back in 2008. And in that case, Madam Speaker, it was held that a property could be proven to be criminal property, not only by proving that an underlying criminal offense had occurred, but also by way of circumstantial evidence. And I gave that example of circumstantial evidence, Madam Speaker. So the evidence would have to lead to the irresistible inference that the property could only have come from criminal conduct. Madam Speaker, Clause 16 amends Section Clause 16 amends Section 196 to make clear that orders in council made pursuant to the UK Extradition Act are also applicable within the Cayman Islands. Madam Speaker, under our extradition regime, we have what is known as the UK Extradition Framework, which is the Extradition Act 2003 was extended to the Cayman Islands and to all the overseas territories in 2016. But under that act, there are order in council sometimes that are made that might have the effect of amending these things. But as worded in our legislation, the Proceeds of Crime Act, when it speaks about the extradition, it doesn't speak about the orders in council that can be made under that piece of legislation. So this amendment is intended to clarify that orders in council that are relevant would also be captured, and for the purpose of extradition offenses, the Proceeds of Crime Act would bite on those as well. Madam Speaker, Clause 17 amends certain provision in Schedule 5 to correct minor errors. The reference, for example, to subparagraph 5 in subparagraph 6.3a and paragraph 6.5 in paragraph 7 as addressing restraint order applications are incorrect. The amendment corrects these errors and substitute in their place the correct provision, paragraph 6.4, that deals with the application for restraint orders. In other words, Madam Speaker, it should have been said paragraph 6.4. Another similar technical error is noted under paragraph 6, subsection 10, which incorrectly references itself as opposed to the correct provision, which is subparagraph 9. The amendment corrects that error, Madam Speaker, so it should be saying paragraph. It should be saying paragraph 9, subparagraph 9, sorry. Clause 18 of the bill, Madam Speaker, which proposes some amendments to Schedule 6, we will deal with by way of committee stage amendment, which has been circulated last evening. Thanks to your good self for approving the amendments. So, Madam Speaker, it's a relatively short bill, but it's a very important bill, Madam Speaker. As I mentioned before, it has a lot to do with the government of the Cayman Islands and the Cayman Islands as a jurisdiction being able to continue, Madam Speaker, to persuade and satisfy the FATF that the reforms that we have put in place to fight the scourge of money laundering and terrorist financing, that those efforts, Madam Speaker, are being sustained. You know, we recently had an audit from the visiting joint group, ICRG joint group, and part of what they're looking for, Madam Speaker, is, well, they're looking for two things in particular. One is that there's a necessary political commitment at the highest level. And secondly, that the reforms that we have, that they are being sustained. In other words, we just didn't do them to satisfy the FATF or the CFATF, but in fact they are meaningful reforms and are being sustained over a prolonged period to continue to fight the emerging, not just emerging, but the existing problem of money laundering and combating and financing of terrorism, and that we are in a position to meet those challenges, Madam Speaker, as they evolve. These persons who are involved in these activities always try to stay one step ahead of the state. We, as a jurisdiction, as a government, has to show and demonstrate to the FATF that we have the capacity to fight these scourges, and, Madam Speaker, that we that the jurisdiction remain very vigilant in ensuring that the legislative and administrative framework that we have in place are compliant with international standard. So I commend the bill to honourable members of this Parliament, Madam Speaker, and seek the support.
Does any other member wish to speak? The Honourable Leader of the Opposition.
Thank you, Madam Speaker. Very briefly, Madam Speaker, just to say on behalf of the opposition that we support the amending legislation in its entirety. We truly understand and appreciate the need for Cayman to keep itself at the forefront in compliance with our international obligations and international best practice, with the intent of ensuring that we are at the forefront in terms of the legislation and framework that we need to keep in place to combat proceeds of crime and combating terrorist financing. With those few words, Madam Speaker, no further comments from the opposition. We support it.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? Then call on the mover of the bill to exercise the right of reply. We've removed your leaning post.
I thank you, Madam Speaker. We obviously unraveled the newly minted lectern. I thank you, Madam Speaker. I thank the Honourable Leader of the Opposition, and I thank all Honourable members for their support. I do thank you.
The question is that a bill shortly entitled The Proceeds of Crime Amendment Bill 2023 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Proceeds of Crime Amendment Bill 2023 has been given a second reading.
Committee on Bills.
The House will now go into committee to consider the bills. The House is now in committee. You may be seated. With the leave of the House, may I assume that as usual, we should authorize the Honourable Attorney General to correct minor errors and as such, the like in these bills. Will the clerk please state the bill and read the clauses?
Public Lands Amendment and Validation Bill, I'll start again. Public Lands Amendment and Validation Bill 2023. Clause 1, short title.
Is there any questions on Clause 1? If not, I'll put the question. The question is that Clause 1 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 1 stands part of the bill.
Clause 2, repeal and substitution of Section 6 of the Public Lands Act 2020 revision, membership of the Commission.
I've received notice of an amendment to Clause 2 and have given the member leave to bring the amendment.
Thank you, Madam Chair. Madam Chair, in accordance with the provision of Standing Order 52.1 and 2, I, the Honourable Juliana O'Connor Connolly, JP, Minister responsible for District Administration and Lands, give notice to move the following further amendments to the Public Lands Amendment and Validation Bill 2023. 1. That the bill be amended in Clause 2 and the proposed new Section 6 as follows. A. And subsection 3 as follows. Little 1. In paragraph A, by deleting the word "and" at the end of the paragraph. 2. In paragraph B, by deleting the full stop and substituting the words "and." And 3, by inserting after paragraph B the following paragraph. C. The other 5 Caymanian members of the public name in subsection 1B. And B, by deleting subsection 6 and substituting the following subsection. 6. The Commission shall be considered as being properly constituted, notwithstanding a vacancy in the office of chairperson, deputy chairperson, or one of the other members of the Commission, unquote.
The amendment has been duly moved. Does any member wish to speak thereto? The question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. Does anyone wish to speak on the clause as amended? If not, I'll put the question. The question is that Clause 2, as amended, stands part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 2, as amended, stands part of the bill.
Clause 3, miscellaneous amendments, deletions and substitutions of various words throughout the Principal Act.
Is there any question on Clause 3? If not, I'll put the question. The question is that Clause 3 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 3 now stands part of the bill.
Clause 4, validation.
I've received notice of an amendment to Clause 4 and I've given the member leave to bring the amendment.
Thank you, Madam Chair. In accordance with the provisions of Standing Order 52 and 1, I, the Honorable Juliana O'Connor Conley, JP, the Minister responsible for District Admin and Lands, give the notice to move the following amendments to the Public Lands Amendment and Validation Bill 2023. 1. That the bill be amended by deleting Clause 4 and substituting the following. Validation 4.1. Where, before the commencement of this amending and validating act, members of the Commission were reappointed under Section 6 of the Principal Act as members of the Commission for a period going beyond the term permitted under the Principal Act, the reappointments are declared to be valid as they would have been if this amending and validating act had been enforced at that date. 2. The acts or omissions of the Commission members referred to in subsection 1 in relation to the Commission shall be regarded as invalid by reason only that their reappointments were for a period beyond the term permitted under the Principal Act shall not be regarded as invalid. I beg your pardon, Madam Chair. 3. The Commission shall not be regarded as improperly constituted during any period up to the commencement of this amending and validating act because of the reappointment of the Commission members referred to in subsection 1 beyond the period of expiry of their second 2-year term. And 2. That the bill be amended in the long title by deleting the word to.
The amendment has been duly moved. Does any member wish to speak thereto? The question is that the amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. Does anyone wish to speak on the clause as amended? If not, I'll put the question. The question is that Clause 4, as amended, stands part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 4, as amended, stands part of the bill.
A bill for an act to amend the Public Lands Act 2020 revision as it relates to, among other things, the composition and terms of appointment of the members of the Public Lands Commission, to validate the appointments of 2 Commission members and the constitution of the Commission, and for incidental and connected purposes.
I've received notice of an amendment to the long title and have given the member leave to bring the amendment. The amendment has been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the title as amended do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title as amended stands part of the bill.
A bill for an act to amend the Public Lands Act 2020 revision as it relates to, among other things, the composition and terms of appointment of the members of the Public Lands Commission, to validate the appointments of Commission members and the constitution of the Commission, and for incidental and connected purposes. On to the next one. Plant Protection Bill 2023. Clause 1, short title and commencement. Clause 2, interpretation. Clause 3, meaning of regulated article. Clause 4, establishment of NPPO. Clause 5, powers and functions of NPPO. Clause 6, Director of NPPO. Clause 7, delegation of powers and functions of NPPO. Clause 8, phytosanitary inspectors. Clause 9, official laboratories. Clause 10, reference laboratories. Clause 11, NPPO committees. Clause 12, principles for phytosanitary measures. Clause 13, designation of quarantine stations and other places. Clause 14, approved forms. Clause 15, requirements for import. Clause 16, exempt and prohibited imports. Clause 17, import permits. Clause 18, inspection of imports. Clause 19, phytosanitary actions on imports. Clause 20, release of imports. Clause 21, designated points of entry. Clause 22, requirements for export of certain plants. Clause 23, export permits. Clause 24, export phytosanitary certificate. Clause 25, re-export phytosanitary certificate. Clause 26, transit authorization. Clause 27, declaration of pests. Clause 28, declaration of pest-free or low pest prevalence area. Clause 29, declaration of pest-free place of production or production site. Clause 30, notification by inspector. Clause 31, declaration of provisional quarantine area. Clause 32, declaration of quarantine area. Clause 33, declaration of phytosanitary emergency. Clause 34, phytosanitary emergency measures. Clause 35, revocation or amendment of quarantine or emergency declaration. Clause 36, notification of pest. Clause 37, prevention of infestation and spread. Clause 38, requirements for dealing with infested plant, product, or article. Clause 39, powers of inspectors. Clause 40, restrictions on power of entry. Clause 41, identity card. Clause 42, dealing with seized items. Clause 43, report to director. Clause 44, inspector may be assisted. Clause 45, obstruction and failing to comply with requirement of inspector. Clause 46, false or misleading information. Clause 47, administrative penalties. Clause 48, forfeiture of items and proceeds. Clause 49, protection from liability. Clause 50, evidentiary certificate. Clause 51, review of decisions of inspector. Clause 52, regulations. Clause 53, repeal, savings, and transitional provisions.
Madam Chair, just before you take a vote on a procedural matter, just because this is the first time that I've seen a vote been taken in such large part. Normally, and I'm not saying that this isn't how we can do it, because it's definitely a lot quicker, but in most votings on committee stage, we would do them in blocks by the part of the act. So, for example, part 1, part 2, on...
Honorable Minister, the reason why we haven't taken any breaks is because there haven't been any amendments. Usually you will do the vote prior to an amendment and then pause. Perhaps we could have stopped at the different parts, but in the interest of trying to get through here quickly, we just did it as a block vote.
Thank you, Madam Chair.
With that being said, the question is that clauses 1 through 53 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 53 now stands part of the bill.
A bill for an act to prevent the introduction of plant pests, to control the spread of plant pests, to protect plant resources, to facilitate trade in plants, plant products, and other regulated articles, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title now stands part of the bill.
Terminal Charges Validation Bill 2023. Clause 1, short title. Clause 2, validation of payment and collection of terminal charges. Clause 3, validation of assessment and payment of penalties for non-payment of terminal charges. Clause 4, validation of orders or determinations by a court. Clause 5, immunity.
Are there any questions on clauses 1 through 5? If not, I will put the question. The question is that clauses 1 through 5 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 5 now stands part of the bill.
A bill for an act to validate the payment and collection of terminal charges between the period commencing 1st October 1997 and ending on the commencement of this act, to validate penalties assessed or paid for the non-payment of terminal charges, to validate orders or determinations of the court relating to terminal charges, to validate certain actions taken in the collection of terminal charges, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title now stands part of the bill.
Proceeds of Crime Amendment Bill 2023. Clause 1, short title.
I've received notice of the amendments to Clause 1 of the bill and have given the member leave to bring the amendment.
Thank you, Madam Chair. In accordance with Standing Order 52.1 and 2, I move the following amendments to the Proceeds of Crime Amendment Bill 2023. That the bill be amended in Clause 1 as follows. A, in the section heading, by inserting after the word title, the words and commencement. B, by renumbering the clause as subclause 1 and clause 1. And C, by inserting after subclause 1 the following subclause. 2, this act shall come into force on such date as may be appointed by order made by the Cabinet, and different dates may be appointed for different provisions of this act and in relation to different matters.
The amendments have been duly moved. Does any other member wish to speak thereto? The question is that the amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendments now stands part of the clause. Does anyone wish to speak on the clause as amended? If not, I will put the question. The question is that Clause 1, as amended, stands part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. Clause 1, as amended, stands part of the bill.
Clause 2, Amendment of the Proceeds of Crime Act 2020 revision. Reference to parts. Clause 3, amendment of Section 2, definitions and interpretation. And Clause 4, repeal of Section 2A, meaning of single family.
Are there any questions on clauses 2 through 4? If not, I'll put the question. The question is that clauses 2 through 4 do stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clauses 2 through 4 now stands part of the bill.
Clause 5, amendment of Section 4, powers, functions and duties of Financial Reporting Authority.
I've received notice of the amendments to Clause 5 of the bill and have given the member leave to bring the amendment.
Thank you, Madam Chair. Madam Chair, the bill be amended by repealing Clause 5 and substituting the following clause. 5.1. The principal act is amended in Section 4 as follows. A, in subsection 2 as follows. 2, by repealing paragraph CA and substituting the following paragraph. CA may disseminate in its discretion or upon request information and results of any analysis to 1, any competent authority, 2, any supervisory authority within the islands, and 3, such other institutions or persons in the islands as may be designated in writing by the steering group, and shall use dedicated, secure, and protected channels for such a dissemination. And B, by repealing subsection 9 and substituting the following subsection. 9, the Cabinet may assign to the Financial Reporting Authority, a public body, a self-regulatory body, or any other person, the responsibility of monitoring compliance with money laundering regulations made under this law in relation to persons conducting relevant financial business who are not otherwise subject to such monitoring by Cayman Islands Monetary Authority.
The amendments have been duly moved. Does any member wish to speak thereto? The question is
Madam
the elected
Chair.
member for West Bay West.
We are dealing with the tabled amendment. Yes.
Committee stage amendment to Clause 5.
Because I had a question to ask, and I don't know if this is the appropriate time, but why the different dates for different matters?
I suspect that to do with the initial, we passed that, but I will assist. Under some of these amendments, Madam Chair, some regulations are going to be required and rules as well. And so the plan, if I might put it that way, sir, is that different sections will commence before others. Some sections will commence before the others. So those that might require regulations and so, those might come into effect later.
So it's for regulations, different times for regulations to be made, and not one set of regulations to cover the bill.
Right. We have several sets of regulations under the Process of Crime Act. So this staggered date will allow us to make regulations for some of these new provisions that we're putting in. So some of them will come into effect immediately, others will wait until the regulations and so on are ready.
Is there any reason why it wasn't in the original bill, the green copy? This amendment that I'm asking about.
I wouldn't say there's any reason. I think what has happened is that as we develop the bill and deal with it and be reviewing it and consultations take place realized that there are other changes that needed to be made. And so,
all right, Madam Speaker, Madam Chair. I thank the Attorney General, but I felt compelled I should have asked. Thank you.
Does anyone else wish to speak on the clause as amended? If not, I will put the question. The question is that clause 5 as amended do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 5 as amended now stands part of the bill. Before we move forward, I just want to make one minor formatting comment, and it's just, which I'm sure legislative drafting will pick up on this, but it's just that subclause D should appear directly under subclause C for that.
thank you, Madam Chair. They have in fact spotted it now.
Clause 6, amendment of Section 9, protection upon disclosure of information to Financial Reporting Authority.
Are there any questions on clause 6? If not, I will put the question. The question is that clause 6 do stand part of the bill.
This is a different.
All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 6 now stands part of the bill.
Clause 7, insertion of Part 2A, immunity of self-regulatory bodies appointed as supervisory authorities.
I've received notice of amendment to clause 7 and have given leave for the member to bring the amendment.
Thank you, Madam Chair, that the bill be amended by deleting clause 7 and substituting the following. Insertion of Part 2A, immunity of persons appointed as supervisory authorities. The Principal Act is amended by inserting after Part 2 the following part. Part 2A, immunity of persons appointed as supervisory authorities. Immunity of person which is a supervisory authority, 14A, notwithstanding the provision of any other act. While carrying out a regulatory function under this act, a person which is a supervisory authority and its delegates, managers, officers, employees, and agents shall not be liable in damages for anything done or omitted in the discharge or purported discharge of their respective regulatory functions, unless it is shown that the act or omission was in bad faith or constituted willful misconduct. Madam Speaker, for the benefit of members, again, I mentioned, for example, that we use the Cayman Islands Institute of Public Accountants to regulate accountants for money laundering purposes. It's a self-regulatory body, it's not a government agency. And so we need to give them the necessary immunity, protection, when they carry out those functions. And the same will happen for like the Legal Services Council when it is doing the regulating of lawyers for anti-money laundering purposes. And so these are bodies that are being given the necessary protection. SEMA has it under the Monetary Authority Act, and the Department of Commerce and Investment has it under the Public Services Management Act. So this is just consistency across the board.
The amendments have been duly moved. Does any member wish to speak thereto? If not, the question is that the amendments stands part of the clause. All those in favor, please say aye.
Aye.
All those against, no. The ayes have it. The amendments now stands part of the clause. Does anyone wish to speak on the clause as amended? If not, I will put the question. The question is that clause 7 as amended stands part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 7 as amended now stands part of the bill.
Clause 8, amendment of Section 79, property obtained through unlawful conduct. Clause 9, amendment of Section 82, application for property freezing order. Clause 10, Amendment of Section 110, Searches.
Are there any questions on clauses 8, 9, and 10? If not, I will put the question. The question is that clauses 8 through 10 do stand part of the bill. All those in favor, please say aye.
Madam Speaker, can I just have the Attorney General just break down amendment to Section 110, 10(7)(a), it says the purpose of the section for Schedule 5 of the words. The minimum amount means 1,000 Cayman Islands dollars.
Thank you. Thank you, Madam. Thank you, Madam Chair. Thank you, Minister. Madam Speaker, Madam Chair, as I mentioned when I was doing the second reading, currently under Section 110, the legislation provides that where a custom officer or police officer goes on the premises and has reason to believe that there are cash, which is the proceeds of crime, or cash which is intended to be used for criminal offense, they may carry out a search for that money. However, what the legislation says, it says it is a minimum amount. But it doesn't say what the minimum amount is in order to trigger that search. And so the position there is that it has to be at least 1,000 CI dollar in order to trigger the search.
Say that again. Sorry, Madam Chair. I'm sorry, I kind of missed the AG's explanation.
So Section 1...
For 1,000, because I'm sorry I missed that. And if you could, please...
Thank you.
Because these are based on complaints. These searches are based on complaints. Huh? What are they based on? Much than people lie. They can lie, you know. Oh.
Sorry, Mr. Member from West Bay. West Bay West. Thank you. So, as I mentioned, if I just read Section 110 of the Act as it is now, it says, at the heading is searches. And the main heading is recovery of cash in summary proceedings, and the subheadline is searches. Section 1110, subsection 1 says, where a customs officer or a constable who is lawfully on any premises has reasonable grounds for suspecting that there is on the premises cash, A, which is recoverable property, which means that it is the proceeds of criminal conduct, or is intended by any person for use in any unlawful conduct, and the amount of which is not less than the minimum amount. That person may search for the cash there. However, it doesn't say what the minimum amount is. It just speaks about minimum amount. So what it will say, for example, is that where the amount is not less than Cayman Islands $1,000, the constable or the customs officer can search for that. So it has to be that minimum amount in order to trigger the search. And what we did is basically just lift the provision from the UK legislation, which is what we patterned ours off, but for whatever reason, we had not put the amount in it. So, £1,000. Sorry? Sorry, sir. Yes.
Madam Chair, thanks to the AG for that clarification.
Question is? The question is that clauses 8, 9, and 10 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 8 through 10 now stands part of the bill.
Clause 11, amendment of section 133, concealing, etc.
I've received notice of an amendment to clause 11 of the bill and have given leave for the member to bring the amendment.
Thank you, Madam Chair. Madam Chair, clause 11 be amended by, the bill be amended by deleting clause 11 and substituting the following. Amendment of section 133, concealing, etc. The principal act is amended in section 133(2) as follows. By repealing paragraph A and substituting the following paragraph. He makes a disclosure to the Financial Reporting Authority and has the consent of the Financial Reporting Authority to commit the act, but this does not apply to a person who committed or was party to the act from which a property derives. And in paragraph B, by deleting the words nominated officer.
The amendments have been duly moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendments stand part of the clause. All those in favor, please say aye. Those against, no. The ayes have it. The amendments now stand part of the clause. Does anyone wish to speak on the clause as amended? If not, I'll put the question. The question is that clause 11, as amended, now stands part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 11, as amended, stands part of the bill.
Clause 12, amendment of section 134, arrangements.
Received another notice of amendment, this one to clause 12, and I've given the member leave to bring the amendment.
Yeah, sorry, Madam Speaker. Clause 12 be amended by deleting clause 12 and substituting the following. Amendment to section 134, the principal act is amended section 134(2) by repealing paragraph A, substituting the following paragraph. He makes a disclosure to the Financial Reporting Authority and has the consent of the Financial Reporting Authority to commit the act, but this does not apply to the person who committed or was a party to the act from which the property derives.
The amendments have been duly moved. Does any member wish to speak thereto? The question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, no. The ayes have it. The amendment now stands part of the clause. Does anyone wish to speak to the clause as amended? If not, I'll put the question. The question is that clause 12, as amended, now stands part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 12, as amended, now stands part of the bill.
Clause 13, amendment of section 135, acquisition, use, and possession.
I've received notice to amendment of clause 13, and I've given notice to the member to bring the amendment.
Thank you, Madam Speaker. That the bill be amended by section 135, acquisition and use. Principal act is amended in section 135 as follows. By repealing paragraph A and substituting the following paragraph, he makes a disclosure to the Financial Reporting Authority has the consent of the financial reporting authority to commit the act, but this does not apply to the person who committed or was a party to the act from which the property derives. And in paragraph B, by deleting the words nominated officer.
The amendments have been duly moved. Does any member wish to speak to the amendment? Question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, no. The ayes have it. The amendments now stand part of the clause. Does anyone wish to speak on the clause as amended? If not, I'll put the question. The question is that clause 13 as amended now stands part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. Clause 13 as amended now stands part of the bill.
Clause 14, amendment of Section 138, disclosure by the Financial Reporting Authority.
Are there any questions on Clause 14? If not, I'll put the question. The question is that Clause 14 do stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 14 now stands part of the bill.
Clause 15, amendment of Section 144, interpretation.
AG keeping us busy.
Thank
I've received a notice of amendment to Clause 15 of the bill, and I've given leave for the member to bring the amendment.
Thank you, Madam Chair, that the bill be amended by inserting after Clause 15 the following clause. Amendment to Section 145, regulations. The Principal Act is amended in Section 145(1)(a) as follows: by deleting the word and at the end of paragraph F, and B, by inserting after paragraph F the following paragraph, FA, to establish a framework under which reporters of suspicions of criminal conduct may seek and obtain defense to specified money laundering or terrorist finances offenses in relation to those reported offenses. And Madam Speaker, just to completeness, I mentioned to the member from West Bay West that some of these would require regulations. That's an example of where the Cabinet is being given authority to make regulations under Section 145.
The amendments have been moved. Does any member wish to speak thereto? If no member wishes to speak, the question is that the amendment stands part of the clause. All those in favor, please say aye. Those against, no. The ayes have it. The amendments now stand part of the clause. Does anyone wish to speak to the clause as amended? If not, I'll put the question. The question is that Clause 14 as amended, Clause 15. The question is that Clause 15 as amended stands part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 15 as amended now stands part of the bill.
Clause 16, amendment of Section 196, extradition where Schedule 1 to the Extradition Act 2003 applies. Clause 17, amendment of Schedule 5, modifications to the Act when applied to external confiscation orders and related proceedings.
Are there any questions on clauses 16 and 17? If not, I will put the question. The question is that clauses 16 and 17 do stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clauses 16 through 17 stands part of the bill.
Clause 18, amendment of Schedule 6, activities falling within the definition of relevant financial business.
I've received notice of the amendment to Clause 18 of the bill and have given the member leave.
Thank you, Madam Chair. Madam Chair, the bill is amended by deleting Clause 18 and substituting the following clause. Amendment of Schedule 6, activities falling within the definition of relevant financial business. The principal act is amended in Schedule 6 as follows: by repealing paragraph 14B and 22, and in paragraph 17 by deleting the words 15,000 and substituting the words 10,000. Madam Speaker, certainly in respect of the amount dealing with the 15 and 10,000, if I might just clarify that for honorable members, benefit, if you give me a second. What happened there, Madam Speaker, is, Madam Chair, paragraph 17, Jesus, it's just trying to finish. If you just, I just need to find it, Schedule 6. Yeah. So, Schedule 6, Madam Chair, deals with activities falling within the definition of relevant financial business. And one of the things that is caught under this provision is the activity of dealing in precious metals or precious stones when engaging in cash transactions that is equivalent to 15,000 United States dollars or more. So it's not just every activity that the precious dealers in precious metals and stone, every transaction that they are required to report if it is suspicious. It's only if they engage in a cash transactions, which is like CI $10,000 or more in cash, then clearly they are required to make a report. So, as it is now, the paragraph is amended to change US 15,000 because that is how it is written. Cash threshold at which a dealer in precious metals and stone is deemed a relevant financial business to 10,000 CI dollars. The amount is necessary to resolve a conflict between the country's two main money laundering laws. Under the Proceeds of Crime Act and the anti-money laundering regulations. Under prior and recently proposed amendments to Regulation 11, 20, and 21 of the anti-money laundering regulations, dealers in precious metals and stones, like other regulated businesses, are required to satisfy their CDD obligations when the transaction's amount is $10,000 or more. However, under paragraph 17 of Schedule 6 of the dealer in precious metals and stone have that obligation when the transaction is 15,000 US dollars, I'm sorry, are the equivalent of CI 11,904. The poker and the MLR are therefore in conflict. So if I might just translate that. We have the Proceeds of Crime Act, one set of legislation, and we have the anti-money laundering regulations, which is another set. One of these legislation, namely the anti-money laundering regulations, says that where, what do you call them, jewelers and those people, where they're dealing with transaction, which amounts to 10,000 CI dollars. or more, then they're required to carry out certain due diligence requirement. Make sure, ask where the money come from, what's the source of funds, and so on. Make sure that it's not laundering money to buy buying jewelry. Under the proceeds of criminal conduct act, it doesn't say 10,000 CI dollars. It says 15,000 CI dollars. But when you convert 15,000 US dollars, it doesn't come out to 10,000 CI dollars. So there's an anomaly. The equivalent of 15,000 is roughly $11,904. So there's a difference in terms of when the obligation arises to do CDD. So what we're trying to do is align the two sets of legislation to make sure that you have 10,000 across the board. And so.
Madam Chair, I am concerned, as I said, first with the $1,000, because I think that could be higher, and now you're bringing this down to 10. From 15 it used to be. And you're deleting the 15, right? And you're deleting 15,000 US, and doing what then? Coming closer to it. Yeah, I'm just have to be very, very careful. People come to your yard and tell you they won't come in and look because they hear you got 15,000 US or you got 10,000 CI, and it can't happen. Don't say it can't happen. AG, I was the subject of a governor who said in the statement to London, all you got to do is to bring the boxes, telling the police, bring the boxes out of his office, and that will convince people that he's guilty. So don't talk about what they can do. The Philistines are the Philistines, always will be. And I was subject, and still is today, of lies and dirt trumped up by an administration that was, let me just stop before I go too far. But no thanks. No need thanks. I should say what I had to say. Because there's too much dirt going on in this country where poor people are getting licked hard and wealthy people getting away with all kind of dirt.
Madam Chair,
I am concerned about the whole thing, but I'm concerned, AG, about the numbers.
Let me just clarify that this paragraph, as I mentioned to you, happens where people who we call dealers in precious metals and stones, those jewelers, and those people walk, for example, say a tourist walk into the jewelry shop and want to purchase a piece of jewelry using $10,000 cash. There's an obligation on the part of the owner of the shop to question where these $10,000 come from, the source of funds. What happened here is that we have two pieces of legislation. One quotes the thing in US dollars and one quoted it in CI dollars. We're trying to streamline it so that instead of having 10,000 CI in one and one speak to 15,000 US, we're just saying 10,000 CI across the board. But it has to do with people who walk into these stores and, for example, want to make purchases using cash of amount of $10,000. That's what that is saying. And so, thank you.
The question is that the amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendments stand part of the clause. Does anyone wish to speak on the clause as amended? If not, I will put the question.
Let's go on.
The question is that clause 18 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no.
No.
The ayes have it. Clause 18 as amended stands part of the bill.
Clause 19, transitional provisions.
Is there any questions on clause 19? If not, I'll put the question. The question is that clause 19 do stand part of the bill.
A bill for an act to amend the Proceeds of Crime Act 2020. Oh, sorry.
The question is clause 19. The question is clause 19 do stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 19 stands part of the bill.
A bill for an act to amend the Proceeds of Crime Act 2020 revision in order to reform that act in the areas of intelligence gathering and investigations to ensure that the act conforms to international best practices, to clarify the evidential basis on which it may be shown that property is criminal property or is obtained through unlawful conduct, to amend the act in order to protect self-regulatory bodies, which are supervisory authorities, from certain liability in the execution of their regulatory duties, and for incidental and connected purposes.
The question is that the title do stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. The title now stands part of the bill. We've reached the conclusion of the committee, and I put the question. The question is that the bills be reported to the House. All those in favor, please say aye. Those against, no. The ayes have it. The bills will accordingly be reported to the House. House will now resume. You may be seated. Honourable members, we've passed the hour of 4:30. I will call on a motion to suspend Standing Order 10.2. Honourable Premier.
Thank you, Madam Speaker. I rise to move the suspension of Standing Order 10.2 to allow the conduct of business of the House to continue past the hour of 4:30.
The question is that this Honourable House do continue past the hour of 4:30. All those in favour, please say aye. Those against, no. The ayes have it.
Reports on bills. Public Lands Amendment and Validation Bill 2023.
The Honourable Deputy Premier.
Thank you, Madam Speaker. Madam Speaker, I have to report that a bill shortly entitled the Public Lands Amendment Validation Bill 2023 was considered by a committee of the whole House and was passed with amendments.
The bill has been duly reported and is set down for a third reading.
Plant Protection Bill 2023.
The Honourable Minister for Planning and Infrastructure. and Agriculture.
Thank you, Madam Speaker. Madam Speaker, I am to report that a committee of the whole House has considered the bill shortly entitled Plant Protection Bill 2023, and it was passed without amendments.
The bill has been duly reported and is set down for a third reading.
Terminal Charges Validation Bill 2023.
The Honourable Minister for Tourism and Ports.
Thank you, Madam Speaker. Madam Speaker, I am to report that the Committee of the whole House has considered the bill shortly entitled the Terminal Charges Validation Bill 2023 and was passed without amendments.
The bill has been duly reported and is set down for a third reading.
Proceeds of Crime Amendment Bill 2023.
The Honourable Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to report that a committee of the whole House has considered a bill, the short title of which is the Proceeds of Crime Amendment Bill 2023, and it was passed with several amendments. I'm sorry.
The bill has been duly reported and is set down for a third reading.
Third readings. Public Lands Amendment and Validation Bill 2023.
The Honourable Deputy Premier.
Thank you, Madam Chair. Madam Chair, I beg to move that a bill short entitled the Public Lands Amendment Validation Bill 2023 be given a third reading and passed.
The question is that a bill shortly entitled the Public Lands Amendment and Validation Bill 2023 be given a third reading and passed. All those in favour, please say aye.
Aye.
All those against, no. The ayes have it. The Public Lands Amendment and Validation Bill 2023 has been given a third reading and is passed.
Plant Protection Bill 2023.
The Honourable Minister for Agriculture.
Thank you, Madam Speaker. Madam Speaker, I beg to move that the bill shortly entitled the Plant Protection Bill 2023 to be read a third time and passed.
The question is that a bill shortly entitled the Plant Protection Bill 2023 be given a third reading and is passed. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. The Plant Protection Bill 2023 has been given a third reading and is passed.
Terminal Charges Validation Bill 2023.
The Honourable Minister for Tourism and Ports.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill shortly entitled the Terminal Charges Validation Bill 2023 be read a third time and passed.
The question is that a bill shortly entitled Terminal Charges Validation Bill 2023 be given a third reading and is passed. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. The Terminal Charges Validation Bill 2023 has been read a third time and is passed.
Proceeds of Crime Amendment Bill 2023.
Honourable Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill, the short title of which is the Proceeds of Crime Amendment Bill 2023, be given a third reading and passed.
The question is that a bill shortly entitled the Proceeds of Crime Amendment Bill 2023 be given a third reading and passed. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. The Proceeds of Crime Amendment Bill 2023 has been read a third time and is passed.
Motions. Government Motion Number 1 of 2023-2024. Amendment to the Development Plan 1997. Proposed rezoning Georgetown East, Block 20D, parcels 447, now 468 and 469, 448 and 451. To be moved by the Honourable Minister of Planning, Agriculture, Housing and Infrastructure.
The Honourable Minister of Planning, Agriculture, Housing and Infrastructure.
Madam Speaker, I propose that the amendment to Development Plan 1997 to rezone Georgetown East Block 20D, parcel 447, now 468 and 469 and 448 and 451. Huh? So the motion. What was this one? What was that? Let me see. Yeah. Madam Speaker, sorry, I just read those issues. Will call me.
Please go ahead, Honourable Minister.
Thank you, Madam Speaker. Madam Speaker, proposed amendment block 20D parcel 447, now 468 and 469, 448 and 451. Madam Speaker, in accordance with Section 10.2 the Development and Planning Law, the 2021 revision, I wish to lay on the table of this Honourable House as a proposed change to the rezoning of Georgetown East, Block 20D 447, now 468 and 469, 448 and 451 from low density residential to neighborhood commercial. Madam Speaker, the members will find before them a written summary of the rezoning application, a map illustration, and a location of the current zone of the proposed rezone area. And finally, a map illustration of the proposed new zoning of submission being discussed. The land, as mentioned in the motion, is currently zoned low-density residential and is located adjacent to the Linford-Pearson Highway between Halifax Road and Silver Oaks Apartment Complex. On the 17th of February 2015, the Central Planning Authority resolved to include the parcel 20D 447, 448, and 451 into an application to rezone block 20D parcel 173, 174, Rim 1, and 175, and 452. The rezone application requests the change to the zoning from low-density residential to general commercial. It was resolved by the CPA to proceed as a neighborhood commercial rather than general commercial, and the CPA further resolved to forward the application for a 60-day public notification in accordance with Section 11.2 of the Development Planning Law 2014 revision as current at the time. During the comments period, no objections or no representations were received. On the 13th of May 2015, the Central Planning Authority considered the application a second time and resolved to forward the matter to the Ministry of Planning, Lands and Housing and Infrastructure as named at the time, with the recommendations to forward the rezone applications to then titled Legislative Assembly for debate subject to Cabinet's approval. On the 14th of July the 14th, 2015, the Cabinet resolved to approve the rezone proposal for 20D, parcel 173, 174, REM 1, and 175 and 452, only omitting the parcels we are discussing today, namely 447 and 451 from the government motion. Madam Speaker, through you, I would like to advise members of this Honorable House that the Chambers reviewed the CPA's decision and added an additional parcel to rezone the application and confirm that the recommendation is compliant with our laws, and therefore the government would like to correct the omission. Madam Speaker, the Cabinet heard the rezone application for the Block 20D, parcel 447 and 448 and 451 on November the 17th to 20th, and the application was supported for onwards motion to the House of Parliament. However, was not progressed. Therefore, thereafter, on February 8th of 2021, Block 447 was subdivided into 468 and 469. Madam Speaker, I'm pleased to say that of June the 6th of 2023, the Cabinet considered the application again and supported the forwarding of this House of Parliament, which is why we are here today. In closing, I ask that the support of the Honourable House for this approval of Georgetown South Block 20D, 447, now 468 and 469, 448 and 451 from low density residential to neighborhood commercial. Thank you, Madam Speaker.
Does any other member wish to speak to the motion?
Madam Speaker, Georgetown North.
Thank you.
Thank you, Madam Speaker. Maybe it's a little late in the evening and I'm having trouble, but I did have a little issue following up. If the member could just confirm for me, I know there's been a long history, obviously going all the way back to 2015. And in his presentation in the paper, he said that there was a mistake that we're coming back now with 451, 448, 468, and 469. But I guess where I'm not catching it is that the original application was passed in November 17th, 2020, but it was in February 8th, 2021 that it was subdivided. So I'm not too sure how it was omitted if it wasn't subdivided until it went through Cabinet in 2020. It was subdivided in February 8th, 2021. And I could be missing something completely. So maybe just talking about it a bit. So it was approved by Cabinet on November 17th, 2020. The rezoning, Cabinet supported forwarding the additional parcel 20D, 451, 448, and 447 to the House of Parliament. But in February 8th, 2021, Block 20D, which was 451, 448, and 447, was subdivided into 468 and 469. And so now you're bringing all of with the new subdivided pieces. So it's the same thing from 2015, just, okay. Thank you, Madam Speaker. Madam Speaker, we didn't have a lot of time to look at this, Madam Speaker, but on the face of it, the official opposition have no issues with the motion.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak? If not, does the Honourable mover of the motion wish to exercise his right of reply?
Madam Speaker, I just want to thank my colleagues and everyone in the House of Parliament for their full support on this motion. Motion titled Rezoning of Block 20D, Parcel 447, now 468 and 469, and 448 and 451. Thank you.
The question is, be it now therefore resolved that in accordance with Section 10.2 of the Development and Planning Act 2021 revision, the Central Planning Authority hereby recommends and submits to the Parliament the following proposal for alteration to the Development Plan 1997, a summary of maps of which are attached hereto. And be it further resolved to alter the zoning area of registration section, Georgetown East, Block 20D, Parcel 447, now 468 and 469, 448 and 451, from low-density residential to neighborhood commercial. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Government motion number 1 of 2023-2024 is duly passed. Can I call on a member to move the adjournment?
Thank you very much, Madam Speaker. I want to take the opportunity, before I move the motion for adjournment, just to thank all members of the various ministry teams and, in particular, the Honourable Attorney General's drafting teams who have been down supporting all members of all ministers with their legislation today. I think we have done a good bit of work today to get through these bills and motions and the various questions. Madam Speaker, with that, I again thank everyone for their attendance. And I move the motion for the adjournment of this Honourable House until 10 o'clock tomorrow morning.
The question is that this House do now adjourn till 10 a.m. tomorrow morning. All those in favor, please say aye. Aye. Those against, no. The ayes have it. This Honourable House do now stand adjourned until 10 a.m. tomorrow morning. I also ask that members aim to make a fresh start at 10 a.m. tomorrow.